At the outset, heartiest congratulations for the centenary year to the Chamber of Tax Consultants. Equally congratulating for this wonderful initiative of Gyanshorts. Next year, we will be entering the 10th year of GST. While the issues relating to compliances seem to be gradually settling, we are clearly now witnessing a big litigation wave. Today, I, Advocate Shah, partner at Economic Laws Practice, is going to be discussing on the issue of applicability of GST on assignment of leasehold rights, whether subject to GST or not. At the heart of this discussion is a simple question: is assignment of development rights leviable to GST or not? Needless to say, the department feels yes, and the assessees feel otherwise. Before getting into detail, let us just understand a little about how this transaction works. Various state industrial development corporations such as GIDC, MIDC, etc. are tasked with the responsibility of steering a planned and sustainable development of industrial houses. They have land parcels which they provide on a long-term lease. Typically, the lease periods in such cases exceed over 90 years. They received an upfront premium, and clearly undisputed such premium that they receive is exempt from GST. They regulate the use of the land so as to ensure that the land are used for the specific industrial purposes. The lessees of such property are allowed to construct structures thereon in accordance with the timelines and the guidance which is given by the state industrial corporations. Critically and importantly, the lessees are allowed to permanently assign the leasehold rights in such lands and building constructed thereon to any other interested buyer. These assignments typically entail A. Obtaining a permission from the State Industrial Development Corporation, the GIDCs or MIDCs, who are the owners of the land. They charge a consideration for giving such transfer, and again undisputed is the fact that GST is payable on the same. Of course, there's a receipt of consideration in the hands of assignor for grant of such assignment of lease, and stamp duty is paid as if the transaction is in the nature of conveyance. Having said this, the moot question now comes is, a lease typically creates an interest in the land. However, when such lease is assigned on a permanent basis, what is it that is being transferred? Is it a supply of goods leviable to GST? Is it a supply of services leviable to GST? Or is it neither but a transaction which is more akin to an interest in immovable property? Therefore, being a transaction may be in the nature of land and building, which is specifically excluded from GST in terms of Schedule 3 of the GST Act. Therefore, logically extending this, what is it that the key question that arises? Is assignment of leasehold rights a transaction in land, not subject to GST, or a building post OC, again not subject to GST, or is it a taxable supply? This is exactly the question that was answered by the Gujarat High Court in the decision of Gujarat Chamber of Commerce and Industry, a 2025 decision. The court has held that GST cannot be levied on transaction of assignment of leasehold rights. The reasoning given by the court is mainly built on three folds. First, the nature of rights. The court has said that these rights are nothing but an extension of an immovable property itself. Long-term leases and assignment of such leases create a transferable interest in immovable property, not merely just a contractual license. Second, the court understood, evaluated, and has noted two limbs of the transactions. First is the lease which is given by the State Industrial Development Corporation, GIDC in this case, and the second limb, most important, which is the subject matter of dispute, is assignment of such leasehold rights by the assignor, the current lessee, to the new buyer. In such cases, they have clearly said that such rights basically divest the original lessee, the assignor in this case, of all the rights that are obtained in the property when they have taken it on lease. effectively to say there is a complete alienation of the rights that were obtained by the person originally when he does an assignment of thus lease. Thirdly, it's a generally settled position that a lease, which is for a period of more than 60, 70, 80 years, is very much an alienation and akin to a sale and a mortgage. The court emphasized that the rights are therefore permanently and completely extinguished, and therefore it is more in the nature of an absolute transfer rather than saying that it is a transaction in the nature of a supply of a service. Having said that, the third leg, the court looked into the statutory exclusion. Under the GST law, as mentioned earlier, there is an exclusion from sale of land and sale of a building post receipt of OC. Now, even in such a situation, any benefits arising out of land, there are several settled decisions such as shared housing, etc., and several definitions other than under the GST law where land includes benefits arising out of land. So they said that any benefit arising out of land also should be treated as akin to land and therefore excluded in terms of paragraph 5 of Schedule 3. Thus, basis the judgment of the Gujarat High Court, clearly GST is not leviable on assignment of leasehold rights. The court said that any such tax which is sought to be levied is ultra vires, and why so? Because indirectly, by levying a tax on such a transaction, what is sought to be taxed is indirectly a land on which there is a clear exclusion. Having said so, what is also important to note is where do we stand today? Post the judgment of the Gujarat High Court, the Gujarat High Court itself in several other decisions has taken a similar position that GST ought not to be levied on assignment of leasehold rights. Coming to Bombay, the Bombay High Court, Nagpur bench in the case of Aerocom clearly held, following the Gujarat High Court decision, that GST should not be leviable on assignment of leasehold rights. This judgment has subsequently followed in a couple of other benches again of the Nagpur bench of the Bombay High Court. Having said so, the Gujarat High Court decision is currently lying at the Honorable Supreme Court. That's right, the department has filed a petition before the Honorable Supreme Court against the decision of the Gujarat High Court. Having said this, in several other petitions before the Bombay High Court, not the Nagpur bench but the Bombay bench as we call it, for the Bombay High Court, has adjourned this matter sine die, which means the court has said that the outcome of this matter clearly depends on what happens at the Supreme Court, and therefore till such time the Supreme Court decides the matter, interim stays and protection have been granted to the various petitioners. Having said this, what will be interesting to observe is what is it that the Supreme Court holds. Whether the Supreme Court goes beyond the pure reading of the law to go ahead and say what exactly is the situation or the nature of such transaction, and therefore does it hold to say that GST should not be leviable on such cases. At the interim, several players who've paid tax on such transactions are also contemplating filing refunds so that they don't lose out on their refund possibilities should the decision be decided in favor of the assessee. Lastly, from a practical reality perspective, what is it that an assessee must do? A, as we see, the department continues to issue notices basis the timelines and the forced timelines that they need to adhere to. They continue to issue notices. Second, considering the fact that an appeal has been filed, they continue to take a position that there is no closure of this issue as yet because Supreme Court is yet to decide. However, no stay has been granted by the Honorable Supreme Court on the decision of the Gujarat High Court. So from an assessee's perspective, purely from a legal perspective, the law stands as it is. The decisions of the Gujarat High Court and the Nagpur bench of the Bombay High Court seem to be in place for the purpose of taking a view that GST should not be leviable on assignment of leasehold rights. This is one such issue currently doing rounds across courts and across various assessees. Under GST, as discussed originally, there are several other matters, corporate guarantee for instance, just to name one of those, which are doing rounds across the high courts. And the litigation wave, we are hoping that with the functioning of the tribunal, a lot of this will gradually settle down to make it a good and simple tax as we've all been contemplating. Thank you.